Your I-130 didn't just get delayed, it may have been silently downgraded. And if you don't understand what USCIS changed in February 2026, you can do everything right, pay every fee, submit every document, and still watch your family-based case slide backwards. Not because the law changed, but because the bureaucracy changed how it chooses winners and losers inside the backlog. Here's the brutal truth. USCIS doesn't have to deny you to devastate you. It only has to move you into the slow lane. And that is exactly what a processing priority shift is. A hidden traffic system where your petition can be treated like an emergency or treated like an inconvenience. Same form, same government. Two completely different realities. In a few minutes, I'm going to show you what this priority shift really means. Who gets fast-tracked, who gets quietly left behind, and the devastating mistake that turns an already long wait into an extra year or more without you even realizing you triggered it. Stay with me, because later I'm going to explain the single most powerful move many families can make to escape the preference category trap entirely, and why waiting even 6 months to do it can cost you years. This is Immigration News Desk. And today, we're not doing a polite update. We're doing an autopsy of how family immigration is actually being processed right now, how the queue is being manipulated, how backlog reduction language masks a triage system, and what you need to do before your case becomes collateral damage. Let's start with what changed. In plain language, USCIS has announced significant changes to I-130 processing priorities in February 2026. That sounds boring until you understand what I-130 really is. For most families, Form I-130 is not paperwork. It is the gate. It is the formal recognition by the U.S. government that your relationship is real and that you're allowed to even stand in line for a green card process. No I-130 approval, no immigrant visa step, no adjustment step, no real movement. The petition is the foundation of almost every family-based case. And that's why shifting I-130 priorities is not a small administrative tweak. It's an infrastructure decision. It determines whose families get reunited first, whose children age out while waiting, whose marriages get stretched across oceans, and whose lives get trapped in the Visa Bulletin purgatory for another season. Now, you need context. People love to imagine USCIS as a neutral conveyor belt. First in, first out. You filed first, you get handled first. That is the myth. In reality, USCIS has always used priorities, formal and informal. Sometimes it's explicit, like certain humanitarian programs. Sometimes it's operational, like shifting officers to different workloads. Sometimes it's political, like a surge at the border causing resources to be reallocated away from benefits processing. But the reason this February 2026 change is so consequential is that it's being presented as a structured priority system that can fundamentally reorder how I-130s move. The government will sell this as service improvement. And yes, there is a real backlog. There are staffing constraints. There are budget realities. But you need to understand the deeper dynamic. When an agency can't deliver timely service to everyone, it stops trying to be fair and starts trying to be defensible. It becomes a risk management machine. It prioritizes what is easiest to finish, what reduces political pressure, and what avoids court challenges. That's not morality. That's institutional survival. Here's the mechanism you're dealing with. Under the previous expectation, I-130s were largely processed in a first-in, first-out rhythm, at least on paper. Under this new February 2026 framework, certain categories and circumstances are explicitly moved to the front of the line. Immediate relatives of U.S. citizens get top priority. Certain aged-out risk cases and humanitarian situations get elevated. Cases tied to employment-based processing in specific cooperative contexts can be advanced. Cases that are decision-ready after an RFE or NOID response can get priority. And then everything else, what the agency will call routine, is effectively the remainder pool. That remainder pool is where preference categories live. That pool is where time goes to die. If you're thinking, okay, so they're just prioritizing the most urgent, that's the surface narrative. Here's the problem. In practice, once you create a multi-tier priority stack, The bottom tier becomes a waiting room that constantly gets interrupted by the top tiers. Every time USCIS pushes more cases into the high-priority pipeline, it steals oxygen from everything else. That is how you get multi-year stagnation in categories that were already struggling. Now I'm going to open a loop, because this is where many families accidentally sabotage themselves. The same system that can prioritize you can also punish you for being sloppy. A single poorly prepared I-130 can trigger a request for evidence, and that can shove you into a different operational track. Later in this video, I'm going to explain how RFEs function like a bureaucratic sinkhole, and how one common evidence mistake, especially in spouse cases, turns a routine petition into a fraud suspicion profile that takes months to unwind. Before we get tactical, you need to understand the other moving part: visa numbers. USCIS does not operate family immigration in a vacuum. USCIS adjudicates petitions and adjustment applications. The Department of State controls immigrant visa numbers and publishes the Visa Bulletin. That Visa Bulletin is the metronome of the entire system for preference categories. When you file an I-130, you get a priority date, usually your filing date. That is your place in the line for categories that are numerically limited. Every month, the Visa Bulletin says which priority dates are current for final action and for filing. For immediate relatives, spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens, there is no annual numerical cap in the same way. That's why those cases are described as always current. They're not competing for a tiny slice of a quota in the same way preference categories are. But preference categories are quota limited. F2A is spouses and minor children of green card holders. F2B is unmarried adult children of green card holders. F3 is married children of U.S. citizens. F4 is siblings of U.S. citizens. And for certain countries with high demand, Mexico, the Philippines, India, China, the per-country limits create an additional choke point. This is why people can wait a decade or two in some categories. The law itself builds a scarcity model. So when USCIS says, we're going to prioritize immediate relatives, it is prioritizing cases that are not constrained by the same numerical limits, which means approvals can translate into real immigration movement faster. That sounds humane. It also has a second effect. It helps USCIS performance metrics. It's easier to show cases completed when the downstream system isn't blocked by quota caps. That matters because agencies are measured. They respond to what they're measured on. Now, let's talk about what this means for you depending on your category, because this is where the stakes become personal. If you are a U.S. citizen petitioning for your spouse, your unmarried child under 21, or your parent, you are in the immediate relative universe. Under this priority shift, you are positioned to benefit, assuming your petition is clean and you don't trigger unnecessary delays. But if you are a green card holder petitioning for your spouse or child under 21 in F2A, you are now in a category that the source text explicitly warns may experience more delay, potentially moving from the old rough estimates of 2 to 3 years to 4 to 5 years, depending on backlogs and country demand. If you are in F4, siblings, some countries were already effectively 15-20 years. Under a system that pushes preference categories down the ladder, you should plan for even longer. That's the hard reality. Now I want you to hear something uncomfortable. The phrase reduce backlog often means reallocate suffering. It means some people get relief and others pay the price. And preference category families, especially green card holders trying to reunite with spouses and kids, are often the ones who pay because they don't have the political narrative protection that immediate relatives of citizens do. Here's why that distinction exists historically. Family reunification has always been a pressure point in U.S. immigration politics. In 1965, the modern preference system was structured to emphasize family ties, but it also baked in caps and categories that create queues. Those queues become political levers. Administrations can't easily change the statutory caps without Congress, but they can change processing intensity and prioritization through administrative choices. That is exactly the type of soft power you're watching now. And that's why this February 2026 shift matters, even if it sounds technical. It changes the speed of the first domino. If the I-130 domino falls faster for one group and slower for another, everything downstream changes. National Visa Center document collection, consular interview scheduling, adjustment of status timing, work authorization planning, and for children, the ticking clock of age-out risk. Now let's walk through the new stated priorities, because you need to map yourself into the system as it actually works. Priority 1. Immediate relative petitions. Spouses, unmarried children under 21, and parents of U.S. citizens. This is the top lane. If you're in it, your mission is not to celebrate. Your mission is to avoid self-inflicted delays, because in a priority system, the most painful outcome is being eligible for the fast lane, but ending up in secondary review because of preventable mistakes. Priority 2. Aged-out cases and humanitarian situations. This includes situations where a child is turning 21 while a petition is pending, and serious emergencies like medical crises, domestic violence, or other compelling humanitarian factors. This is USCIS acknowledging a moral and legal reality. Timing can destroy eligibility, and certain harms are unacceptable to prolong. But you need to understand how the agency thinks here. Humanitarian priority is not granted because you're suffering. It's granted because you can prove the suffering in a format the government recognizes. Later in this video, I'm going to tell you the documentation standard that separates compelling from ignored, because most expedite attempts fail for one simple reason. They are emotional narratives without evidentiary architecture. Priority 3. Certain employment-based cases related to family-based where cooperation allows quicker resolution. This is vague in the source text, and vagueness is itself a clue. When agencies create interoperable processing lanes, it usually means they're trying to maximize throughput by bundling decision-ready cases. It's a throughput strategy. Clear what can be cleared fast. Again, metrics. Priority 4. Cases where an RFE or NOID response has been received and the case is ready for decision. That sounds like good news if you just responded to an RFE, but it hides a trap. If you respond poorly, your case isn't decision ready, it's fraud suspicion ready. A weak RFE response can produce a denial that forces you to refile, lose time, and in some cases lose eligibility if circumstances change. So yes, respond fast, but respond correctly. Speed without strategy is how people destroy their own filings. Priority 5. Routine cases. No special circumstances. This is where many preference category petitions live. This is where you can feel the floor drop out under your timeline. Now what should you do right now? Not someday, not when you get around to it. Right now, before your case gets processed under a new internal logic. First, do not panic, but also do not underestimate administrative reordering. Panic makes you do dumb things. Complacency makes you do nothing. The correct posture is controlled urgency. If you haven't filed your I-130 yet and you're eligible, file as soon as possible. That's not motivational talk. That is mathematical reality. Your priority date is usually your filing date. Every day you delay is a day you donate to the backlog. In preference categories, a late filing doesn't just mean later approval. It means later placement in a quota line that can move painfully slowly. Waiting for things to get better is not a strategy. It's a surrender. Now here's the devastating mistake I warned you about earlier. People delay filing because they want a perfect packet, or because they're waiting for one document, or because they're afraid of an RFE. So they do nothing. Then they file late anyway, and now they have both problems, a late priority date and a messy packet. You want early and clean, not late and clean, not early and messy, early and clean. Second, file accurately and completely. Under a priority system, USCIS will not slow the entire pipeline to rescue you from your own errors. A missing translation, inconsistent dates, weak relationship evidence, or unclear marital history can trigger an RFE. And an RFE is not just more time. It is a reroute into a different operational workflow, often involving different officers, different queues, and sometimes deeper scrutiny. Let's be specific about spouse cases, because this is where RFEs multiply. USCIS is not just verifying that you have a marriage certificate, it's evaluating whether your marriage looks like a real life. If your evidence is thin, no joint financials, no shared residence proof, no credible timeline, USCIS can treat your petition as higher fraud risk. Not because you're a fraud, but because the agency is trained to detect patterns and anomalies. You protect yourself with layered evidence: wedding photos, travel proof, joint bank or insurance, lease or mortgage documents, utility bills, communication records, affidavits if appropriate, and consistency across every form and supporting document. If it's a parent-child case, the documentation is different. Birth certificates, adoption orders where applicable, legitimation documents in certain jurisdictions, proof of name changes, and any records that resolve inconsistencies. If your documents contain errors, misspellings, wrong dates, fix them now through proper legal channels where possible. Do not ignore small errors. USCIS loves small errors because small errors become big doubts. Third, if you already received an RFE or NOID, treat your response like litigation, not like homework. The source text indicates decision-ready RFE responses can be prioritized. That can be a lifeline. But only if your response is comprehensive, organized, and directly answers what USCIS asked. A sloppy response is worse than a slow response because it can lead to denial and force you to restart the process. Denial isn't just time lost. It can affect your credibility profile in future filings. Now here's the critical revelation I promised about escaping the preference category trap. If you are a green card holder and you are eligible to naturalize, naturalization can transform your family's category. It can convert certain petitions into immediate relative status, which is the top priority lane and generally not subject to the same visa number limitations. This is not a trick. This is not gaming the system. This is built into how categories function. If you've been a permanent resident for 5 years, or 3 years if you obtained residency through marriage to a U.S. citizen and meet the requirements, you may be eligible to apply for citizenship. Once you become a U.S. citizen, a petition for your spouse or unmarried child under 21 can become immediate relative, removing them from the capped category logic and putting them into the fastest priority stream under the February 2026 shift. But here is the part that hurts people. Naturalization is not instant, and filing late costs you twice. You lose time waiting to naturalize, and your family stays trapped in the slower preference flow while you delay. If naturalization is an option for you, it is one of the few levers you can pull that can compress years of waiting. That's why it's so important, and that's why so few people do it in time. They don't realize it's a lever until it's too late. Now let's talk about Hail Mary strategies people consider when preference categories slow down, because this is where scams and self-sabotage explode. Some families explore parallel options like employment-based visas for the beneficiary while the I-130 is pending. In some cases, that can be legitimate. If your spouse qualifies for a real work visa and a real employer is willing to sponsor correctly, it can create a separate pathway. But do not treat a temporary visa as a magic tunnel. Misrepresentation, inconsistent intent, or sloppy filings across multiple tracks can create contradictions that haunt you at interviews. The government cross-checks. More than ever, if you're going to pursue parallel pathways, do it with professional counsel and absolute consistency. Now let's talk about children aging out, because this is where families lose decades in one silent moment. If you have a child approaching 21, you need to understand the Child Status Protection Act, or CSPA. CSPA can freeze a child's age for immigration purposes in certain circumstances, but it's not automatic, and it's not intuitive. There are calculations, there are deadlines, there are sought-to-acquire requirements in some contexts. Families miss CSPA protection because they didn't track the clock, or because they didn't take the required step in time when the priority date became current. That is the kind of devastating mistake that doesn't just delay you, it changes the category, and the category change can add years. If you have a child near 21, you should not be getting your CSPA guidance from a comment section. You should be getting it from an experienced attorney who will calculate your timeline based on real receipt dates, approval dates, and Visa Bulletin movement. Now let's return to the reality of country-specific backlogs, because denial is often born from unrealistic expectations. If your beneficiary is from Mexico, the Philippines, India, or China, per-country limits can stretch preference categories far longer. Under a priority shift that favors immediate relatives and decision-ready cases, the pressure on preference categories can feel even worse. Planning matters. Emotional planning and financial planning matter. Families crack under long separations. People make desperate decisions. Desperation creates vulnerability to scams, to bad legal advice, to risky travel, to fraudulent shortcuts that can trigger permanent bars. And yes, scams are coming. Whenever USCIS changes priorities, a shadow market forms around expedites, connections, and special officers. Let me be blunt. Anyone promising guaranteed speed through inside channels is selling you a lie that can destroy your case. The only real expedite mechanisms are official, documented, and evidence-based. If someone is asking for money to bribe, to push, to unlock, you are not buying speed. You are buying risk. Now, I want you to understand something about expedite requests, because the agency will never explain this clearly. Expedite is not, I miss my family. Expedite is, there is a documented specific harm that meets USCIS criteria, and delay will cause irreparable damage. Medical emergencies require detailed physician letters, diagnoses, treatment plans, and why the beneficiary's presence is materially necessary. Domestic violence or abuse scenarios require police reports, protection orders, medical records, counselor letters, and coherent timelines. Humanitarian claims must be built like an evidentiary case file, not like an emotional plea. If you do this wrong, you don't just get denied expedite, you sometimes invite scrutiny that slows the underlying petition. Now I'm going to give you the operational checklist you should be thinking about, but I'm going to frame it the way USCIS does. Reduce friction, avoid flags, and create decision-ready files. Keep your address updated with USCIS. Not eventually, immediately. File AR11 when you move, because missed notices lead to denials, and denials lead to refiling, and refiling leads to lost time and new fees. This is one of those small mistakes that turns into a multi-month catastrophe. Create a USCIS online account and monitor your case status, but do not treat the online status as the full truth. Notices still matter. Deadlines still matter. If you have counsel, make sure both you and your attorney receive notices and that you have a system for tracking response deadlines. Maintain updated relationship evidence over time. Many people front-load evidence at filing and then stop documenting the relationship. Years later, when you finally reach an interview, you scramble to prove continuity. That scramble creates inconsistencies. Inconsistency is what officers interpret as deception. Build your record slowly over time. Shared finances, shared travel, family events, communications. Consistency over years is persuasive. Monitor the Visa Bulletin monthly if you're in preference categories. Understand the difference between final action dates and dates for filing. One tells you when visas can actually be issued. The other tells you when you may file certain applications depending on USCIS's monthly chart selection. People miss windows because they don't know which chart applies. Now, one more strategic lever many families overlook: multiple eligible petitioners. If more than one qualified family member can file an I-130 for the same beneficiary, in some situations multiple petitions can exist, and the beneficiary can ultimately proceed based on whichever becomes usable first, depending on category and timeline. This is not always efficient and not always advisable, but it is a real strategy some families use. If you're considering it, you need legal guidance because the wrong approach can waste money without gaining time. And now let's address the emotional core of this. You're being asked to wait in a system that has changed the rules while you were already in line. That's why people feel betrayed. That's why families spiral. But if you want to survive this, you have to stop thinking like a hopeful applicant and start thinking like a compliance manager. Your goal is to avoid the administrative triggers that shove you into slower tracks and to pull the few levers that can legitimately move you into faster categories. Here's the most important framing you should hold on to. This February 2026 I-130 priority shift is not merely about speed, it's about triage. And triage systems reward what is easy to verify, what is decision-ready, and what reduces visible political pain. They punish complexity, ambiguity, and disorganization. That means you can't control the backlog, but you can control how clean your file is, how fast you respond, and whether you qualify for category upgrades like naturalization. If you do nothing, you are letting the system decide your family's timeline, and the system is not designed to prioritize your pain. I'll continue tracking how USCIS implements this in the real world, how different service centers apply it, whether RFEs spike in certain categories, how quickly immediate relatives actually move, and what happens to the preference category queue as resources get shifted. That's what we do here at Immigration News Desk. We translate bureaucratic moves into survival strategy without sugarcoating the stakes. If you want one final takeaway to anchor this, file early, file clean, respond like your future depends on it. And if you're a green card holder who can naturalize, stop treating citizenship as optional. In the new priority landscape, citizenship is not just an identity, it's a lever. Stay sharp, stay organized, and don't let a quiet policy shift turn you into a forgotten file at the bottom of the pile. This is Immigration News Desk. Keep your notifications on, because the next guidance drop is where we'll find out whether this shift is a temporary backlog tactic or the new normal.